Section 2, as I've already submitted, it endeavors to create more transparency, where the power has been, which was under the rules vested in the Chief Justice, has now been
call it a sharing of the burden.
Sharing of
it's
the
a
burden.
Huge burden.
Yes.
Why think of it negatively? Think of it positively.
My Lord,
I don't want this burden. I want to share it with my colleagues. So what?
Fantastic, my Lord. That ends the matter as far as Section 2 is concerned.
Absolutely.
Absolutely. And because what it does is...
So I don't trust them. That's the only other way. I can't trust them.
It is in this time
when
we want the justice system to be more efficient. It actually helps. There are more minds sitting together trying to work out how to make things more efficient and transparent in order to aid the litigants who come before your lordships. And if I may say so, the primary duty and obligation of this court is under Article 185, exercising appellate jurisdiction. 184.3 is rare cases which come before you under 184.3. It is actually the appellate jurisdiction of this court which this court is duty bound to exercise. So anything and everything which advances that objective, that constitutional objective, must be supported, must be upheld. There is no fundamental right which gets offended or violated by advancing this objective. And Section 2 endeavors to do as much.
So if that was the objective, the law again be changed if at some stage the government or the parliament decides that no, 3 judges are not enough, let's do it by ballot. So you would amend the law accordingly?
My Lord, if I may.
Or let's do it, why 3 judges, why not all 17 sitting and deciding which cases go where?
My Lord, if I may respond to this.
Yes, sure.
My Lord, if the pendency is down to 20,000, absolutely there would be no occasion. But if it goes to 75,000, there might be.
Why not 10?
Zero.
But
this is what is being sought to be addressed.
You will attend to a matter on that thing. I don't think parliamentarians, we should disparage parliament all the time. If the situation is that there's no pendency, maybe they would have not come up with this thing. Maybe if the damage caused by various was not done, they would have not come up with this thing. So parliament doesn't operate in a vacuum. It hears, the government is part of it, opposition is part of it, all these people are part of it. They think and they produce something. Maybe not in the most perfect of things, but we have to, each legislation must be supported unless it's clear-cut violation of the ultra-vires of Constitution fundamental rights in 184.3. Otherwise, it can be ultra-vires of Constitution 199.
And my Lord, the power remains vested in this court.
But Mr. Attorney General, suppose there is a parliament that is elected in the next general election. On your theory, would that parliament not have the power to repeal this law? Of course. No. You see, you are saying this is a law
If it repeals it, yes.
That this is a law affecting having such a salutary effect, it is having this, that and the other. So someone can say, जी parliament का तो power ही नहीं है, तो ये law को repeal कर दें. या फर्ज करें अगली पार्लियामेंट आती है वो सेक्शन 2 को फारिग कर देती है, वो कहती है जी चीफ जस्टिस का पावर है वो, दैट्स गुड इनफ.
माय लॉर्ड
सकती है, आपसे पूछ रहा हूँ.
जी.
देखिए अवान साहब मैं देखें प्लीज, मैं उनको भी रोका था और मैं आपको भी रोकूंगा. मैं कंजूस पे नहीं जाऊंगा, मैं रियलिटी पे जाऊंगा. ये कानून आ गया, अब अगली दफा कोई केस ले आएगा हम वो वाला भी देख लेंगे. मैं ओपिनियंस कभी नहीं दूंगा. आप हमारे या तो एडवाइजरी जुरिसडिक्शन इस्तेमाल कीजिए, हम ऐसे आपको ओपिनियंस नहीं देंगे. आपका काम है अपनी सरकार, अपनी गवर्नमेंट को ओपिनियन देना. हमारा काम है उसको उसकी कॉन्स्टिट्यूशनलिटी वैलिडिटी आप देखें, खत्म. हम आपके ऊपर मफरूजे नहीं डालना चाहते हैं कि क्या होगा. भाई हमें क्या पता क्या होगा, जब आएगा हम देख लेंगे. बहुत सारी चीजें आप कर लें प्लीज इस कानून पे और आगे बढ़ा लें बात को, क्योंकि हम देखिए कोर्ट आप समझ नहीं रहे हैं इसकी अहमियत. हम लोग बैठ के इधर एक कंडीशन गवर्नमेंट में बैठ रहे हैं, लोग कोई जेल में मर रहा है, किसी का केस है. मेरी तो मुझे तकलीफ हो रही है. सुबह से 57,000 है. अब हम छोड़ के जाएंगे 150 और बढ़ जाएंगे, कल 150 और बढ़. आप चला लें 1 महीना केस, हमें क्या फर्क पड़ता है. फर्क इसलिए पड़ता है क्योंकि हम तनख्वाह ले रहे हैं इस गरीब आवाम से एक काम करने के लिए कि उनके केसेस का फैसला कर लें, खत्म। ये बहुत अच्छी डिबेट है, जाके हाई कोर्ट में कर लें चैलेंज, वो आ जाएगा जजमेंट नंबर 94 में, हम बड़े पूरे पावर्स के साथ बैठ के इसको देख लेंगे। आपको पता है आज बेंच बनाने का क्या इशू था, इसके बावजूद के स्टे चल रहा है। मैंने अपने 2 सीनियर कलीग से पूछा कि मैं ये करने जा रहा हूँ, 2 स्टे चल रहा है, अलग बात है आइन कानून पर स्टे चल रहा है, फिर भी बात को आगे बढ़ा के किसी खत्म कर लेना, सराह लें कानून को, ये तर्क कर दें, मगर आप अपने दलाइल दें, हम उसका सुन लेंगे और फैसला कर लेंगे। कोई इख्तलाफ करेगा, कोई नहीं करेगा, उनकी मर्जी है, हमें आपको परसुएट करने की कोई जरूरत नहीं। आप हमें परसुएट कर लीजिए और सवाल का जवाब नहीं देना चाहते मत दीजिए, हम आपके खिलाफ कर लेंगे फैसला।
My lord, my learned friend is questions.
No, sorry. I'm not indulging in conjectures.
My lord,
I'm asking you a question in order to understand the principles that you are saying and arguing and submitting before the court.
my lord,
I'm not engaging in theoretical argument.
my lord.
I'm trying to understand the basis on which you are defending the
My lord,
constitutionality of this law.
आपका सवाल।
So therefore my question stands. Tomorrow if Parliament were to make this a law and say, let it go back to the Chief Justice in his sole capacity, would that is within Parliament's competence?
My lord, if that is so,
Learned
and if it
Attorney
so
General.
happens,
Question.
Yes,
This is
Learned
not
Attorney
conjecture.
General.
This is to
Learned
establish the
Attorney
principle.
General.
You accept
Learned
that?
Attorney
absolutely,
General.
my lord, absolutely.
Learned
This is
Attorney
in Parliament's competence, and if I may say so, my lord,
You have
I have,
provided assistance.
I have,
Your
as
answer is
Attorney General.
absolutely.
Ji, absolutely.
Yes.
Yes.
Okay.
Mr. AG, to your right.
Ji.
Section 2 में it provided that the bench, constitution of the bench. Suppose bench is constituted. Who will assign the cases to the benches? Still this power has not been given in this act. Again, there will
My
be...
lord, the committee determine its procedure, and then it, with regards to how the meetings are to be, the committee itself.
Who will assign the cases that this case will be fixed before this bench? And one thing more, if 2 members, senior members comes to the conclusion, say tomorrow the Chief Justice will sit in Quetta Registry for 1 month, for 6 months, or for 1 year. Is it possible?
My lord,
What would we do if this situation occurs?
My lord, the committee has to, under subsection 2, after the commencement of this act, the committee had to hold its first meeting for the purposes of determining its procedure, which would have included when and how the meetings were to be held, and the constitution of benches, etc. But that never happened because the law was suspended, or well, the bill was suspended before it became an act, which was also, if I may say so with regret, was a first.